Today, I speak with Tim Brisibe, Vice President, Tax and Estate Planning at Mackenzie Investments. We talk about testamentary trusts. And if the idea of half of your estate landing in the bank account of your child on your death makes you a little uneasy, continue listening. And we talk about how trusts can project your intentions after your death. Tim, welcome.
Thank you.
Nice to have you here. Today we are going to be talking about, drum roll, testamentary trusts. So, not how to spell it, but testamentary trusts.
Testamentary trust, yeah.
Perhaps we can take a step back and go, what is a trust?
Yeah.
And then secondarily, what is a testamentary trust?
Very good, and thanks for having me. It's an important topic. So as we take a step back, testamentary trusts, but we'll talk about what is a trust. Mm-hmm. A trust is, it becomes an individual taxpayer. It's its own entity. Mm-hmm. It is a construct that has what we call the settlor and the trustee and the beneficiary. So there are three entities in a trust. And so the settlor settles the trust, identifies a trustee and also their beneficiaries, but there is an asset that is placed in the trust for the benefit of those that will benefit from the trust, which are the beneficiaries. So that is essentially what a trust is.
So you've got, so let's kind of review that there. So let's just say the asset, let's just say there's, the $1 million.
Correct, yep.
That's here. You've got a beneficiary.
Yep.
So let's just say there's a child that's down here. So they're the beneficial owner to all of this. You've got a
settlor.
Who's
settlor.
that?
So if we are linking this now, leaning into a testamentary trust.
Okay.
The settlor is the will maker. And so a will maker is the person that has drafted a will, otherwise known as a testator. So if
a lawyer?
No.
Okay.
So it's, for me, I'll use myself as an example.
Okay.
I have a will. I went to a lawyer and had them help me draft a will. Okay. And in my will, there is a trust. Mm-hmm. I am the testator. I am the will maker. And so I am setting up a testamentary trust in my will for the benefit of my children.
Okay.
And so if we further, what is a testamentary trust? So we generally have an idea of a trust. It's a vehicle that holds assets set up by someone for the benefit of other people.
Yeah, so
right?
so we hear, trust fund babies. That's
correct.
That's kind of in the casual language out there.
Yeah.
So that's where a trust, an entity with assets, is set up for the benefit of a child or
Let's
adult
call them
child.
Children, yeah.
Children, and then so the settlor kind of gets everything in there, and then the trustee is
manages, oversees the assets within the trust for the benefit of the children.
So typically, I'll say typically, when people pass away, you got your house, you got your savings, you got your RSPs, somebody passes away, it all goes to their spouse potentially, and then on the death of the second, the money just lands in the bank accounts of the beneficiaries, call it the children.
Yeah.
So with the trust, you're not necessarily directing the funds directly to the children. Yeah. You're directing it somewhat to this entity.
Very good, and I'll pick it up from there. So you direct it to this structure, and in a will, it's called a testamentary trust, right? And that trust takes effect upon death. So based on what you described, the first spouse passes away. There is a surviving spouse that generally can receive things tax deferred, right? And once the surviving spouse passes away, then you've got the estate now, and it's got all of these assets, right? A terminal tax return will have to be filed, And then, based on the terms of the will that set up a trust within the will, the trust is now fully funded.
Okay, so the trust gets the $1 million.
Correct.
Why are you going through this exercise? Why did the individual put that language, that instruction
in the will?
This is the $1 million question.
Very good.
But this is, why would an individual, a parent, somebody say, I don't want my child to get the money directly. I want to put it into this entity, which sounds complicated.
Very good.
So why would somebody do that?
So speaking with a client a number of months ago, the parent acknowledged that his child had substance abuse problems.
Okay.
And one of the recommendations that we gave this client was perhaps you probably want to think about a testamentary trust for your child. And the habit consumes tens of thousands of dollars. And so in order to protect the child from themselves, you set up this structure upon the parent's death. While the parent is alive, they can take care of their child however they deem fit. But upon their death, you want to set up a vehicle that at least can incrementally provide support to your child who is otherwise not working and has no access to funds, but you're gone now. And so the recommendation was perhaps set up a testamentary trust, stick the $1 million in the trust, and you have a trustee. And here's where we might even talk about a distinction. You've got what's known as a fully discretionary trust.
Yep.
And then you have a non-discretionary trust. In this instance, perhaps you want to lean more toward a fully discretionary trust. And what it means in essence is the trustee has discretion.
They decide.
As to what they pay, the value of what they pay, when they pay, and income, whether or not they pay income or they pay capital to the child, based on how they think, they believe the child is doing. Do they need more or do they need less? And so that would be a fully discretionary trust. So that would be one reason why parents might want to consider a testamentary trust.
So in a discretionary trust, again, you're giving discretion
to the
conscientiousness of the trustee.
Correct.
To act in the
best interest of the beneficiary.
And who would act perhaps like you.
Correct.
To say, carry on what we've been doing, keep going. Whereas a non-discretionary trust, there can be more.
It is fixed.
If you're creating rules around, it can only pay out $20,000 a year.
Or 5%, or 10%, or income, or capital. And you are compelled as the trustee to pay out $50,000 every year. And perhaps that's too much money for this child. So that's why I would probably recommend a fully discretionary trust. So that's one reason why you want to think about a testamentary trust. Another reason would be you have a child that's disabled.
Okay.
A beneficiary with a disability might not, it could be any number of disability, any type, right? They might not be in a position where they can manage their affairs themselves. And so you probably want to think about what is called a qualified disability trust. And that trust can also be a fully discretionary trust, which generally the public would think about what's known as a Henson trust.
Yes.
Yeah. So a Henson trust is generally known as a fully discretionary trust. And you can also have a qualified disability trust, a QDT, for a beneficiary that is disabled. And it helps them with planning. Again, someone, the trustee, helps to look after the financial affairs of that beneficiary. And I'll add this, that some beneficiaries also are on social support.
ODSP, I think.
ODSP,
Yes.
that's
In Ontario.
In Ontario
Disability.
is ODSP. In BC, it's called PWD, Persons with Disability. That's the program. And there are thresholds. There are income thresholds. There are asset thresholds. And so if a child is on ODSP and you still want to provide for that child, then perhaps a fully discretionary Henson Trust might be the way to go, because it protects.
It doesn't interfere with the support from the
that
government.
they're receiving
So it
from the
allows you to
government.
continue on. Okay.
That's the second reason. There are all kinds of reasons. Minor children cannot enter into a contract, can't receive that asset directly.
It would be in trust by default.
Perhaps, yes, you want to set up a trust for minor children.
So we've got potentially a child who's got some substance abuse issues, somebody with a disability.
Yeah.
We could say, somebody who's maybe just not great with money.
Not great. Let's just say not great with money. Or perhaps you want to protect assets from a spouse.
Okay, there's
the spouse of a child, or creditors.
Or creditors.
That's also one of the reasons why people set up
a trust is immune from creditors.
Yeah,
and that's
right.
because it's not actually your asset.
It is not your assets. And again, if it's a fully discretionary trust, a creditor might not be able to make a claim against the assets that are held in the trust because the beneficiary has no rights.
Because it's discretionary
upon the trustee's discretion.
Got it. So it's not theirs to kind of give away.
Yeah.
So there are four clear. I mean, there's
yeah, before.
But there's four of ones where you say, I've got this wealth that is going to be transmitted down to a child, to another generation. Number one, I don't want it to harm them.
Correct.
Like it's because for some, a large gift could really be damaging.
Very good.
To them physically and mentally. Mm-hmm. So you want to mitigate that with the trust. Others, you just don't want to see it go away in a divorce or spending or things like that. So you create this. So you talked about it. So, okay, we created the trust. The $1 million goes in. We know the beneficiary.
Yeah.
But then there's this other actor that you talked about. There's this trustee. So who is that?
You mentioned earlier that the trustee would take, I gave the example of this child that has addiction problems, right? That a trustee would essentially act as though they were the parent that just passed away. Mm-hmm. And so where I'm going with this is, who is this person? Do they think like me? Do they have any exposure to this child? Is it a relative? Is it a friend that knows my family? Mm-hmm. Is it someone that is trustworthy? Is it someone that I can depend on, rely on? And so there are all of these things that we really need to think about. It could be the executor of your estate, and more often than not, in Ontario it's called the estate trustee. Okay. The executor, more often than not, the executor becomes the trustee of any trust that is set up within your will. It's just a fluid...
That's automatic, or is that...
Not necessarily.
Okay.
Yeah, the terms can be used interchangeably, but if you have an actual trust that you have set up in your will, then you need to name a trustee. And for most people, I would say, the executor slips into that role of trustee. You would have provided for that as you're naming the executor and also the trustee.
Because you're entrusting them with the distribution of your assets. So why not?
And then you entrust them also with the managing this trust with the assets for the benefit of your children.
So the trust makes complete sense kind of conceptually to me. Mm-hmm. And then when it kind of hits the reality of the road, okay, so I go, okay, my 25-year-old child, is not that great with money. Mm-hmm. Maybe they got a substance abuse issue. Who knows, whatever it is. Yeah. And you go, I want to protect this money.
Yep.
We're all going to live a long time these days. So the trust, in theory, could be around for
a long time.
For 50 years.
A long time, yeah.
And are trusts in existence for 50 years, or because that could be multiple people. Like should
Yeah.
you view it that long, or say we're going to kind of protect the funds for 10 years and then wrap this whole...
That's right. I think it depends. I'll go back quickly with respect to trustees. Trust companies can also act in that capacity. But
Who would exist in perpetuity?
They exist in perpetuity, right?
Yeah.
And they function across the country for many trust companies. So, but in response to your question just now, we won't get into this, but there's something called the rules against perpetuity.
Okay.
You know, with respect to trust, it is possible to wind up a trust if all of the beneficiaries are in agreement. But if you have a trust that, you know, you want that trust to go and extend beyond a particular generation, you can open up a class.
Oh boy.
Yeah, you can open up a class of beneficiaries that
Yes.
might make it more difficult for beneficiaries that are existing at that time to ask for the trust to be shut down, because it might be for future beneficiaries. So the class is open.
So you're really looking multi-generationally.
Multi-generational, that's where you want to go with that kind of planning. But to your question, if you wanted the trust to last for, say, 5 years,
Yes.
then it's a testamentary trust we're talking about. You provide for that in your will. What some would do is what's called staggered payments. Mm-hmm. So at age, you pay my child, let's assume this is a non-discretionary trust. Mm-hmm. You pay my child 5% of the income and or capital every so often. At age 21, you pay them 25% of the capital. At age 26, 5 years later, you pay them another 25% of the capital. And you keep paying income. Let's assume they wanted to purchase a principal residence. The down payment comes from the trust. At age 30 or 35,
They get the remainder.
they get the remainder. And then if it's discretionary, then it now depends on the trustee whether or not the child has hit not just age milestone, but how they handle themselves and how they handle money.
Oh, so discretionary can rank above those age dates.
In addition to.
In addition to.
In addition to, I reviewed a will once, and this is very interesting. The parents set up a trust for an only child, a son, and so this is an example that answers your question directly.
Okay.
You know,
I got to remember my question now.
and it was just closing out the trust. When do you wind it up?
Yes.
You know, and so the dad drafted his will, and in the will provided for a testamentary trust for his son. And at age 65, the son receives the balance that's held in the trust. At age 65. And at this point, when we were reviewing this will, the child was 35.
Oh my gosh.
So you had 30 years, and it is finite. At age 65, no discretion as to releasing the funds earlier. And one of the other things you put in a trust or in a provision would be, what if the child dies before 65? There are contingent beneficiaries that you plan for. That goes into more planning. But in this case, at age 65, he receives the balance of what's held, and that's it. So he knows his child. And he thinks that I probably don't want him to have access to everything
Until
even
later.
at 63.
The trustee, the person overseeing the trust.
Yep.
Should that be, I mean, we talked about a family member being there.
Yeah.
I can see it causing rifts and tensions. You talked about the child with the substance abuse issues of tens of thousands of dollars. And imagine that their sister was the trustee, and like the tension that she's controlling the assets, the funds, the purse strings, and he wants it. So, I mean, I'm not.
No,
I'm just saying things need to be considered on how it may apply to relationships and.
And you are absolutely right. What I'll say is, families. It is imperative that families have conversations. Absolutely imperative that families have conversations. You may have a child in that particular circumstance. Let's say they don't know how to manage money, and this is the reason you're setting up a trust.
Yes.
For their benefit. You've got two kids, one can, one cannot. Do you set up a trust with both of them as beneficiaries?
So it doesn't have to be parallel. So it can be two different.
There you go. And so that's a question that you need to consider in speaking with your professional advisors as clients. The reason I say families, it is imperative that families have conversations is the ability and the space for children to hear directly from their parents as to their thinking. Mm-hmm. I think down the road, we've had instances where, another example, there's a file that I administered, administering estates for a trust company, and there are 3 daughters. The eldest was named as sole executor. The younger siblings didn't like that.
Power imbalance.
They didn't like that. And the eldest, in my view, administered mom's estate as well as anyone, and she had the help of a trust company in doing that. So the documents were in order, everything was done properly, but the sisters wanted proof and more proof, and they wanted an accountant forensically to go through everything their sister had done. It was not a large estate, and I kid you not, at the end of this process, because lawyers were involved now, accountants were involved to review what she'd done for 2 years prior. The fees to the accountants and the lawyers were huge. In the final analysis, I can remember this very clearly, that we cut a check of approximately $50 to each of the beneficiaries.
That was the net result.
They had received some, but because the estate had bled resources to paying lawyers and accountants, this was what was left. Because you also have to have what's called a holdback for taxes.
Yes.
Just in case there's assessment after the taxes have been filed. This is, in response to your question again, it's a trust company might be the entity that steps in, because we've had siblings, one was named as not just executor, which is fine because you administer the estates for, let's say, 36 months.
Yes.
Right?
It's temporary.
It is temporary, but if it's a trust, it could last for 15 years. And so younger, in some cases, younger sibling, it becomes the trustee overseeing assets for an older sibling, and there is resentment.
Resentment is the...
All kinds of things would result out of that.
So you're suggesting
that
a neutral third party, which is a trust company, which unfortunately costs money.
It costs money.
But it could preserve relationships between siblings, between
the price,
aunts, uncles, everybody.
That's right. The price you pay to preserve family harmony cannot be overstated.
Yes.
And so this might be a good price to pay to preserve relationships.
That's a huge point.
Yeah.
Because at the end of the day, we're trying to, through a trust, is help protect a child, and we don't want disharmony. It's not the result that we're looking for.
Why would you want disharmony if you're trying to protect a child?
I know it's
at odds.
Yeah,
so we need to think through these things and how to make this happen in a manner that would preserve relationships.
Okay, so we're doing all this stuff.
Yeah.
We've used our hypothetical $1 million.
Yeah.
But a trust, as you said, is a separate entity. It needs a tax return.
Yep.
There's regulatory compliance around it, fees, accounting fees that go with it. When does it start to make sense, dollar-wise, to start thinking about a trust? I mean, in my mind, you go, well, it's certainly not $50,000.
I wouldn't set up a formal trust for $50,000. There's something called in-trust for accounts. We won't get into that just now.
No.
And those are, $10,000, $20,000, $30,000. But we're talking, use $1 million again as an example, not as a benchmark, but just as an example, so people have an idea of what they might consider. Now, the dollar value makes sense. You have to think through that. But the circumstance of your child also will inform whether or not you want to set up a trust with $300,000.
Okay.
Substance abuse, I'd rather do this to preserve my child's life. But then because of compliance and reporting and taxes and all of that, you probably want the dollar amount to be higher.
But to your point, I don't care about paying a high accounting fee versus the balance if it's going to ensure that my child is safe and doing well. And you go, that's okay, I'll pay fees.
It's a nuanced conversation, and so all of these things need to be taken into account.
Okay.
Yeah.
So bottom line that I'm taking away from this is if you feel that one of these scenarios, and there's other scenarios we haven't even talked about, applies to you, come talk to us.
Correct.
And we'll sort through it and talk it out. But if there's an itch, let's get through that to go through it. Because these are not decisions that you make and apply in a weekend. This takes months and perhaps years to fully flesh out.
Yeah, that's right. And that's where you come in. Your role is important, if not really significant, because you speak with your clients every day. You have conversations with your clients. You understand your clients, I dare say, better than the lawyer that will help draft a will. And so what you're doing here, and perhaps you have folks in the community that you even work with that you can entrust your clients into their care.
Yes.
To put together solid plan in consultation with parties as best as they can disclose information to you or the other way around. But the point I'm making is that the advisor-client relationship ought to be extensive to include something like this, where you help them talk through things. Have you considered this? And have you considered that? And perhaps think about this. And then you go to a lawyer with this in mind.
A sketch of how it may look.
Yeah.
And then they can
put the
tighten
legal
it together.
documents together.
Got it.
All kinds of things have gone into informing the type of document, the will, that ultimately the client will sign.
Tim, I think that's a natural place to end the conversation here, and perhaps for me to start a conversation with clients if they feel that this applies to them. Better to talk it out and we can cross it off the list, or if we do want to further explore it or even engage a professional lawyer to look at things, we can do that. So Tim, thank you so much. I appreciate the stories because it makes it more real and all the insights that you had. So I appreciate that. Thank you.
Thank you. Thanks for having me. Happy to do this.